I'm attorney Neil Shouse. I used to be a DUI prosecutor, and now I defend citizens accused of DUI. Everybody knows that recreational marijuana is now legal here in California. But DUI of marijuana is still very much a crime. And in fact, now that more people are using cannabis, we are seeing a lot more cases of people getting arrested for DUI of marijuana. In terms of penalties and punishment, these cases are treated almost exactly the same as DUI of alcohol. That is, on a first offense, you can expect probation, fines, DUI school, and sometimes even jail time. But from a defense lawyer's perspective, DUI of marijuana cases are often easier to defend. That is, it's oftentimes easier to beat a charge of DUI of marijuana than it is to beat a charge of DUI of alcohol. And really, I think there are three reasons why that's the case. First, there is no per se limit when it comes to the amount of marijuana in your system. So with alcohol, there is a strict limit of 0.08. The law says if you drive with the BAC, blood alcohol concentration, of 0.08 or higher, you are by definition liable for DUI. But that's BAC, blood alcohol concentration. There is no comparable threshold for BMC, or blood marijuana concentration. So to prove up a DUI of marijuana case, the DA has to rely on other evidence that is just not so clear-cut. Second, the results of a blood or urine test for marijuana are much less revealing. Say you blow into a breathalyzer and it reads a 0.09. The DA can bring an expert witness into court who will sit down in front of the judge and the jury and be able to say with a fair amount of certainty that you must have consumed a certain amount of drinks within a certain amount of time before the test. But with weed, the picture is much hazier. The blood or urine test can show that yes, there are metabolites of marijuana in your system. Yes, you consumed marijuana at some earlier point, but it's much more difficult to extrapolate from that how much marijuana you consumed and how recently you consumed it. The third reason it's easier to beat a DUI of marijuana charge is that there is simply a lack of scientific evidence that marijuana impairs driving ability in the first place. There are a lot of scientific studies with regard to alcohol that if you drive drunk, the alcohol actually impairs your judgment, slows your response time, lowers your motor skills, and reduces your ability to divide attention. Now, police and prosecutors would like to say that marijuana affects you the same way, but the actual scientific studies really fail to support that claim. Now, let me be clear. My advice to everyone is, do not drive if you are high at all. If you've smoked or consumed cannabis that day, then stay home, or get a designated driver, or call an Uber, but don't get behind the wheel. It's just not worth it. On the other hand, if you have been arrested and charged with DUI of marijuana, do not simply go to court and plead guilty. This is a situation where a good defense lawyer can oftentimes get the charges reduced or dismissed and spare you the harsh consequences of a DUI conviction. If you have questions or need help with a DUI of marijuana charge, we invite you to call us 24 hours a day here at the Shouse Law Group.